This is Courtroom 5 South in the Eastern District of Missouri, and I'm Bonnie Claire, the Chief Judge for the United States Bankruptcy Court for the Eastern District of Missouri. Together with my colleagues, Judge Kathy Surratt States and Judge Brian Walsh, as well as the team from the clerk's office and Dana McWay, our clerk from court, and a few special guests, we're delighted to have you join us this year as we once again talk about the changes that will affect our practice in the coming months. As things stand right now, we anticipate that the proposed local rules changes will go into effect on December 1st, 2025, to coordinate with the national bankruptcy rule changes. This seminar offers an opportunity for us to discuss those rules and tell you about some of the effects they will have on the practice going forward.
What you have for this morning is we are going to go over the rules as Judge Claire had indicated. We're going to start first with our local rule changes. Then we're going to move to the federal rule changes, along with some new forms that the federal government has determined are appropriate for us to use for all of our practice. Then we're going to focus in on some CMECF changes that we need to make to effect all of the other changes we just went over. We are fortunate to have with us our Chapter 13 trustee, Diana Doherty, who will talk to us for a short time on some issues that she needs to focus our attention. And we are also going to be joined by James Treese from the Missouri Department of Revenue, who will give us another good idea of what's coming forward in the new 2026 year. Also wanted to give you some housekeeping information. Effective on January 1 of 2026, Judge Brian Walsh will be part of the rotation for accepting new Chapter 13 cases. And we will also change the manner in which we assign our adversary proceedings. We will have those adversary proceedings stay with the same judge who has the main case. Again, those are effective on January 1, 2026. We have transferred some cases to Judge Walsh in preparation for this. We posted that information on the court's website yesterday with a master list of the cases that have been transferred. As a practitioner, you might want to take a look at this to see if indeed one of your cases is on that list. If so, then you're going to want to make sure you know which docket you are attending properly to represent your client. And so you're welcome to contact us here in the clerk's office. We will give a helping hand as needed to take care of this.
We've put together a presentation this morning that runs you through the changes to our local rules of bankruptcy procedure. This morning, you'll hear from all of the judges as well as the clerk of court and members of her staff on some of these items. At this point, we'll go ahead and bring in Matthew Ritter, who's our Chief of Operations here at the court, to talk to you about changes to Local Rule 1002.
Good morning, everyone, and thank you, Judge Claire, for that introduction. I'm here to talk about 1002, which you'll see by the strike through below that the absence of a verification of matrix or matrix is no longer a reason to decline filing. Previously it was, but now we're going to be treating those the same as we would other documents in local rules 1002B, C, D, and E. If, when reviewing a new case, the court observes that the matrix and/or verification of matrix has not been filed, we will issue a new deficiency order requiring those documents be filed within 7 days. We'll hand mail a copy to the debtor so that they would receive that timely. That said, you can still expect a phone call from the clerk's office. Since we cannot assign a trustee and set a meeting of creditors without creditors in a case, we encourage attorneys to still address this promptly all the same. And now I hand the presentation over to Judge Walsh, who will speak about amended schedules and their effect upon deadlines.
Okay, Local Rule 1009E. This is a rule that we amended last year at this time, and we have some further refinements to the rule. The current version of the rule provides that if you add creditors to the schedules or the matrix and issue the appropriate notice, there's an automatic extension of the deadline to object to the discharge or dischargeability of the debt. The federal rules, however, 4004B, 4007C, and D require a motion by a party in interest to extend that deadline. So we have changed our local rule to be consistent. The local rule now requires a motion to extend the deadline. And the rule also provides a reminder that after the deadline has expired, it can be extended only in very limited circumstances. So it's essential to confirm that the schedules and the matrix include all the creditors before the deadline passes, and really sufficiently before the deadline passes, so that creditors can file a timely 523A action, or you may have a problem with 523A3. And local form 26, which is the notice that goes out for this purpose, will be updated so that it's consistent with the new rule. I think we now turn to Judge Surratt States for Rule 1017.
All right, thank you, Judge Walsh. So next on the list is Local Rule 1017-1, motions to dismiss. This rule is going to be changed to update and give debtors 7 days to respond when the trustee requests dismissal for debtors' failure to appear at 2/341 meetings. We're making this update so that council has an opportunity to file some response that they may deem appropriate before the court proceeds to address and rule on the motion. So that should be, I think, maybe a welcome change so that council has that time to respond before the case is ruled on that motion to dismiss. I'm also going to talk about Local Rule 2002-1, which is addressed for services. This rule has been changed to make an addition to clarify some of the most common service problems, and it includes talking about service of the registered agent of an entity, an officer or managing or general agent of a corporation, a particular government agency or official, or an officer of an insured depository institution. These are the types of notices that we seem to have the most issue with when there is service to be made on that. So that is to clarify what addresses need to be used for service of process on those entities. All right, now I believe, Dana, you're going to talk to us about Local Rule 2016-3.
Absolutely. And everyone, I'm sure, will be glad to know we are retaining, of course, the two options that we've had for a number of years, the flat fee option, which, of course, is at the $5,800 mark. But we also have done some clarification on the fee app option. Of course, you're working through the plan with this one where the dollar figure is $3,600. And we're trying to make it clear that this is what you're getting through the trustee's payment, is not the only thing to worry about. This is the amount that you are getting. The $3,600 is the total amount you are receiving, not just what the trustee is paying through the plan. Now, if you, of course, have additional funds that you would be receiving from another source, you need to file a fee app in the regular course to identify those fees and have court approval for them. So if that is the case, a subsequent fee application would be filed in accordance with our local rules. Moving on, we have changed another rule. This is 2016-4. Again, this is on trustee fees, and this is more of a housekeeping matter. We had always had a dollar figure that had to be paid up front to the case trustee in a Chapter 12. We had this at a $500 mark, but we have moved this to the $1,000 mark. This is something that we had not just cleaned up the rules when we had made this change, and now this is copacetic, is just very consistently figured out now. Let me move you on to Rule 2091 and Judge Walsh.
Okay, Rule 2091, if you can see it on the screen, the whole thing is red, which might suggest that that it's entirely new. Really, it's just streamlined and clarified. The substantive changes here are not that significant. The first is that if you're going to withdraw in favor of another member of the bar who's entering at the same time, you can do that by notice. You don't need a motion. The previous rule would allow you to do that only if the two of you were members of the same law firm. Now, two lawyers who don't practice together but are substituting simultaneously can proceed with a notice rather than a motion. Whether you're withdrawing in favor of another lawyer or because there are no pending matters involving your client, you do need to have the client's informed consent, and the forms will be updated to include a representation that you have the client's informed consent. Second, if you use a motion to withdraw, when that is required, it has to state whether the client expressly consents to the withdrawal. And if you don't have that express consent, you need to state that, and then we may wait a little longer to see if the client responds before we grant that motion to withdraw. And then third, no matter which variety of document you file to withdraw, it has to be served on the client, and it has to be done under Rule 7004. So for example, if your client's a corporation, you're going to need to serve an officer. If your client's a insured depository institution, you're going to need to follow that rule. And there will be conforming updates, as I mentioned, to local forms 30 and 31 that will correspond to the changes to Rule 2091. Next up, I think we have Matt Rodman with Rule 3001.
Thank you, Judge. I'm going to cover the next two rules for us. First being 3001, proofs of claim. So what we've done with this rule, it seems like there's a lot of X'd out red there. It's more of a cleanup than anything. The changes made to remove references to outdated processes, specifically related to the exhibits summary and provision of exhibits separately from a proof of claim. And then we did some cleanup, clarifying that claimants are required to serve a proof of claim on all, or proof of claim and its exhibits on all relevant parties. So there's a little bit more language in there, like, or relevant portions thereof, if consented to by the recipient. We've removed that to just clarify that it's going to be complete copy on all relevant parties there. And then we will go to number 9, and this one's a very, very simple change. We've, in 3002, general proof of claim filing provisions have removed a reference to Chapter 9. Upon our review this year, we realized that Chapter 9 does not include a provision for a conversion to another chapter. So there was really no need to have a reference to Chapter 9 in this particular subsection of 3002. And so we've gone ahead with removing that reference to Chapter 9. We can move on to our 10th change in our program, and that's going to be covered by Judge Claire. Judge Claire?
All right, next up is Local Rule 3015-2. Once again, we're talking about fees. You may wonder how we come up with these numbers, and these numbers are determined after we hear from the Local Rules Committee and talk with some other counsel and the trustee about dollars and cents. In this case, we're modifying Local Rule 3015-2 to permit the amount that can be paid in paragraph 3.4 of the Chapter 13 plan to permit more fee payments earlier, and bringing that number up to $2,900, minus any attorney fees paid directly by the debtor that will be paid at paragraph 3.4. Now, this is not a required change, but it is a permitted change if you and your client decide that the plan can support it and still fund sufficiently. I'm also covering Local Rule 3015-4, which deals with confirmation procedures for Chapter 12 and Chapter 13 plans. Our clerk's office has reported to us that the last pre-BAP-CEPA cases have finally closed and concluded. And so we reviewed the local rules this year for any language that was ameliorated as a result of BAP-CEPA. Changes were made to both Local Rule 3015-4H and J. On Local Rule H, and I'll note the materials do not clearly include this language, we deleted language that specifically permitted the court to waive the 21-day objection period and moved it to a different place. And in J, we deleted language that provided that the failure to serve a confirmation order comprised cause to set aside the confirmation order, and changed it to a failure to serve the order may constitute cause for imposition of sanctions or other appropriate relief. If you're working in one of these chapters, please take a look at the rules. And now we'll turn this over to Judge Surratt States to talk about post-confirmation amendments and modifications.
Thank you, Judge Claire. So Local Rule 3015-5 has had some amendments to it, which are talking about post-confirmation amendments and modifications in Chapter 12 and Chapter 13 plans. The changes here are just to take out some outdated versions of the rule that don't reflect our current practice, and to also remove some language that dealt with pre-BAP SEPA rules. So basically the rule is still the same, other than taking care of those things. I always like to remind counsel when you are filing a post-confirmation amendment to your Chapter 13 plan, please be sure to have a motion to go along with that so that the Chapter 13 trustee is aware of what changes are being made and can conclude her review promptly of that matter so that we know whether or not there are any objections. The other local rule I'll talk about now is Local Rule 3022, which talks about final decrees in a Chapter 11 case. The change to this rule is just to clarify the fact that when you have a Subchapter 5 case, there is not a final decree and it doesn't apply in those cases. There's also a change to formally include that your application for a final decree is among those things that could be set on negative notice and not set for hearing. So those are the changes to that rule, just to clear those two things up. All right, Judge Walsh, I think you're up next.
Okay, Local Rule 4001-6. This is another one that's all red, but the reason this one's all red is because it's new. But it's related to 4001-1, which touches on the automatic stay. So as you know, if you deal with motions for relief from the automatic stay, which I think everybody does, under Section 362E, the stay may terminate if the court hasn't conducted a hearing or issued a ruling or ordered the stay extended by certain deadlines. And so we have Local Rule 4001-1 with provisions that attempt to balance the parties' rights to, so the stay doesn't terminate before the court can hold or conclude a hearing. The new rule is similar, 4001-6 is similar, but it addresses the co-debtor stay under Section 1301. And because 1301D provides for the co-debtor stay to terminate in some circumstances 20 days after the creditor files the motion, rather than 30 days under 362E, we need some different requirements. So in new subsection A, we make clear that the movement must serve the co-debtor, among other things. Subsection B provides that hearings ordinarily have to be set on 21 days notice. But if you file a motion under Section 1301C2, which is the provision with the 20-day deadline, you can set that on 14 days notice, unless you're also combining it with a regular plain old stay relief motion under 362D for acts involving the debtor or the estate. In that case, you need to do the 21 days notice like you would ordinarily do. If a co-debtor motion is set more than 20 days after the filing of the motion, the rule provides for a waiver of the 20-day deadline, just like you have in 4001-1B for a regular stay motion. Subsection C says that a response is due 7 days before the hearing, the normal practice, unless the hearing is set on less than 21 days notice. And in that case, a response can be presented at the hearing as you would have with an expedited or an emergency motion. You don't need a motion to expedite to set a 1301C2 co-debtor stay motion on 14 days notice, but you'll need to use noticing language similar to what you would do for an expedited or an emergency motion. And then finally, D says that otherwise the provisions of 4001-1, the regular stay relief, apply to a co-debtor stay motion. So that's complex and technical, but should cover the situation where we have the automatic 20-day termination of the co-debtor stay. And up next, we have Judge Claire.
So this year, we propose modifying Local Rule 4002-1 regarding designation of a responsible individual in Chapter 7 cases filed by a non-individual. Where did this rule come from? The Rules Committee proposes new rules and changes, and we got on board with adding this rule last year. But the rule has been reworked to clarify the procedure for requesting designation of a responsible individual. You need to have a Chapter 7 case with a non-individual debtor, an application by a party in interest for entry of an order appointing a natural person to be responsible for the duties and obligations of the debtor, and then a hearing in the case on that. The hearing may occur on an emergency or on an expedited basis. And if the person who's designated ceases to perform their duties, then a party can file an application with the court to appoint a successor natural person, or advising the court that no one is willing and able to perform the duties at which point the court can determine whether it needs to take other action. The reason we have this rule is in order to ensure that Chapter 7 cases are not filed for entities and the principals all disappear, where no one completes schedules or statements or appears for the 341. The benefits of bankruptcy are available to those who participate actively in the process, and this rule seeks to make sure that that actually occurs. Next, reaffirmation agreements, Local Rule 4008. This clarifies when hearings will occur on reaffirmation agreements. The court will conduct a hearing either when the debtor's attorney does not sign off on the reaffirmation agreement and the bankruptcy code requires that we hold a hearing, or in the event that the court is going to consider disapproving a reaffirmation agreement under Section 524 M1 of the code, which is where there's an undue hardship in the case and the reaffirmation documents fail to sufficiently explain where the money will come from to make payments under the proposed reaffirmation. Now I'll turn this over to Matthew Rodman for a little bit on summary judgment.
Thanks, Judge. The next rule that we will discuss is 7056, motion for summary judgment. The change here is a conforming change. We've taken some conforming language from Federal Rule of Civil Procedure 56, and you'll see those additions there in red, just to conform with what the rules of civil procedure require. So you'll see, or explain why the adverse party cannot produce admissible evidence of the fact. And then conversely, when we're dealing with responses, add some language to add or explain why the materials cited by the movement do not establish the absence of a genuine dispute. This is language that comes straight from the from the civil rules. And we just wanted to add those to be consistent with the civil rules. Our next rule that I will discuss is 8001, dealing with appeals. This was also a conforming change to one of our federal rules, this time Federal Rule 8009 A1B. Essentially, you'll see that striked out language there saying what the deadline is if the designation of record is not filed with the notice of appeal, when it must be filed by. That deadline is found in the federal rule that's cited. So we opted to make it consistent with the federal rule and change that language to make that very, very clear. So that's the only change there. Moving on to our next rule, I am going to hand it over to Dana, and she's going to cover requests for extension of time.
Well, thank you. And this is Rule 9006. This is in the same vein as what we just heard from Matt Rodman about conforming with the federal rules. Our local rule had basically said you need to ask for permission to extend time before the deadline is met. But we recognize that there are some portions of the bankruptcy code and other federal rules that expressly permit a request for extension of time after the deadline has passed. And so we have recognized that and putting conforming language to show that indeed, if you have a statutory term or a rule that permits that, that of course, then you can ask for that request for an extension of time. With that, let me turn this over to Judge Walsh.
Okay, Local Rule 9011. There's a lot going on here. I'll try and cover the basics, but I recommend that you review the language carefully. The revised rule combines aspects of our existing Rule 9011 with some of the elements of the COVID era general orders, in particular 20-4 and 24-1, that suspended the requirement to obtain original signatures from debtors. So first of all, subsection C now, which is new, states that this rule applies to documents that are prepared for use in the case or proceeding that include the signature of someone other than the filing attorney. So most often this will be your client. You're filing something with the signature of your client on it, but it could be a third party. For example, if you have a declaration from a third party supporting something that your client is asking you to do. But note that at the end of C, in the hanging paragraph, if you will, it says that it excludes, 1, a document that's notarized by a notary public, or 2, a document that was prepared and executed without your involvement. So, for example, if you have a copy of a loan agreement from 2 years pre-petition, that was signed by whoever it was signed by, and you can submit that as an exhibit, you're not responsible for determining that it was properly signed. But of course, you have to comply with Federal Rule 9011. You can't submit something for an improper purpose. So by filing a document that is covered by the rule, you're representing that the person signed it. That's consistent with the existing practice and rule. And by representing that the person signed it, that means one of three things has happened. First, I'm sorry, that means that all three things have happened. First, you presented or transmitted the entire document to the signer. Second, if the signer is your client, you verify that they've received it and they've reviewed the whole thing, and you've discussed the substance and purpose of the document with them. This step isn't required if it's not your client, but again, Federal Rule 9011 always applies, so you can't submit something for an improper purpose. And the third thing that must have happened is one of four options for the actual signature. First of all, the first option is you have a wedding signature. Second, you can have commercial signature software. You can use that and have it produce its output. Third, you can have an electronic image of the entire document, including the signature page. So this could be a PDF scan, this could be a fax, this could be a JPEG, a photo of the entire document. And then fourth, only if the signatory is another lawyer admitted to practice in our court, you can have express written consent to affix that lawyer's signature. So this would typically be a stipulation of facts or a consent motion or consent order or something like that. Note that this last alternative is a change from our pandemic era practice where you could get a client's express consent to affix the client's signature, but not have a copy of the complete signed document. With a return to normal health conditions, we're moving back towards normal practices on signatures, although this still allows more flexibility than we did before the pandemic. Subsection D gives you three options for filing a document that's signed by someone else. You can have a PDF scan of the whole thing, including the signature. You can have the output from the digital signature program, or you can have a conformed copy with /s/ and the person's name. And then E, which used to be C, includes conforming changes. You still need to retain your evidence of signature for 2 years after the matter is closed, and you need to provide it upon request. So again, there's a lot going on in this rule. I recommend that you read it carefully, but that's an overview of the key provisions. And I think that brings us to Dana for 9015.
All right, this rule is another conforming change to make it in line with the Federal Rule 9015, and of course on jury trial demands. We don't have very many of those. I can count on probably both hands in 25 more plus 27 years how many jury demands we've had. But if in case you feel that's appropriate in your case to have a jury, then this is the rule for you to look at. And if you do not make it clear what your issues are that you want a jury trial for, then it is the court, the judge, who will be trying those issues. And this rule is making that very clear about that. And again, all pretrial proceedings will be conducted by that bankruptcy judge. We took out where it's approval through use of a pretrial order. We may use something besides a pretrial order. However this would be conducted doesn't have to be specified in the rule. So it's really more of a conformance issue than anything beyond that. Let me move you on to Judge Claire.
So my next rule is Local Rule 9037-1, which deals with the issue of redaction of documents. Please keep in mind, counsel and parties are responsible to redact their own documents. The court will not redact your documents for you. We've changed the rule to clarify when a complete Social Security number has to be provided as per the bankruptcy code, bankruptcy rules, or official forms. And that's with regard to the B-121 Social Security number statement that counsel are all familiar with, as well as the bankruptcy petition preparer notice and declaration, and the disclosure of compensation by a bankruptcy petition preparer. Short, sweet, and simple. Judge Walsh?
I'll try and keep this one simple too. Local Rule 9061. So Judge Surratt States mentioned earlier that Local Rule 3022 has been amended to provide an application for final decree may be served on negative notice. So we've added that to 9061A. And then subsection E is new. A rule has always required, for a long time at least, has required a notice of hearing when someone responds to a motion served on negative notice. But we've never actually provided the language to be used in the notice of hearing. The standard language in Local Rule 9060 doesn't quite fit because of the different objection process and objection deadline. So the rule just now lays it out for you. Here it is right here. Here's language you can use when noticing a matter when someone has responded to a negative notice matter. And back to Judge Grant.
All right, and I will end us up with local rule 96-2, matters without a hearing. The change here has just been made to add that motions to withdraw as counsel or to substitute as counsel has been added to that list, as was we discussed previously, Judge Walsh, when he talked about the motion, the various ways to withdraw from a case.
So we're going to talk about the federal rules of bankruptcy procedure now. The summary of amendments can be found on the links at the top of the page here for the materials that we've prepared for you. It seems like it's a light year, and there's only 2 rules that are changing. Although I would suggest that you our Chapter 13 practitioners dig deep into the change to Rule 3002.1. It is a fairly significant change that we're not going to go super heavily into. There was a brown bag that was presented here in the court a couple months ago that covered this. I would suggest going in and doing some research on the U.S. Court's website and other sources to really immerse yourself in this rule if this is an area that you practice in. But the idea of this rule is to avoid any surprises at the end of a case, right? So early on in the rules, subdivision B is kind of amended to provide more detailed provisions about notice of mortgage payment changes for home equity lines of credit. Conversely, the notice of mortgage payment change form, which we'll cover forms in a second, has been amended to add an area for HELOCs to be included. There have been some stylistic changes to the rule that kind of carry on from a bunch of the stylistic changes that we saw in last year's rule making process in 2024. Most importantly, I think this is new, and I haven't been around as long as others, but this is the first time that I've seen rules changed where a certain form must be used. It's laid out in black letter. You must use this rule. We'll show a couple of those rules, but pay close attention to that. It seems very clear that that it's not going to be file such and such motion in substantial conformity with this form or file this motion, but it seems very clear that thou must use this official form. New with this rule is a motion to determine the status of the mortgage. And so that's something that's I think going to help help debtors, trustees, and the like kind of midstream of the case, which we didn't have before, where anytime after a confirmation but before the plan has completed, a trustee, a debtor is going to be able to file a motion to determine the status of the mortgage. There'll be a 28-day response period for the creditor, for the claim holder, and then some of those issues can be resolved before the end of the case even happens. The notice of final cure that the trustee is going to file has changed slightly. Instead of 30 days, that's now going to be 45 days. With a slight change in name, it's now the notice of disbursements made that will be filed at the end of the case. Again, there'll be after that, then a motion to determine, determine final cure and payment of the mortgage claim can then be filed depending on the outcome of the trustee's notice and then the response thereto. Dana, I think let's maybe we take a look at these forms real quick and then circle back to 8006, just since we're kind of on a roll. Does that sound okay?
That sounds fine.
Perfect. Yeah. So you're going to see all these form changes that we've listed here for you. Again, these are mandatory forms that must be used. And so these first 2 I'm going to highlight just because they're new forms. So that motion to determine status of the mortgage claim, this is what it looks like. This is what's going to be required to be used. As you see, pretty detailed in terms of the information that it's looking for there. That must be used, and then we will also take a look. There's also a corresponding response form I bring these up because this is a new thing, a new procedure, but all of those forms are going to be on the U.S. Court's website. I will note right now, I don't believe they appear on the list of forms that you can choose from, but if you go to pending form and rule changes on the U.S. Court's website, and then you'll be able to look at pending bankruptcy form changes. You'll be able to access them there. Complete at the bottom with committee notes on the process, procedure, and some of the rationale behind the changes to those forms. Again, we said there's a response to trustees' notice of disbursements made, along with a little bit of some bullet points of the procedure behind that form. And then at the very end of a case, if it gets to that point and it's needed, that new motion to determine final cure and payment of the mortgage claim, and the corresponding response. And then, as I mentioned, the notice of mortgage payment changed down there at the very bottom. Slight minor revision just to provide some space for an annual HELOC notice there. There are some director's forms. I did not include those with any rationale. Those are not mandatory forms that must be used, but to the extent that you're interested in knowing what the director's form changes are, there is a link there to be able to go ahead and access those and take a look at those. That's one of our two changes. Kind of all the forms correspond with that 3002.1 change. It's only one rule, but it is a big one. So again, the court would strongly urge you to kind of immerse yourself in that and take a hard look at that if that's an area that you practice. The other rule that we have that's changing is Rule 8006, excuse me, and Dana's going to talk a little bit about that one.
Fine. Just before I do, Matt Rodman had mentioned to you that you can find these forms in the rationale, et cetera, in the pending portion on the uscourts.gov website. I understand that on 12/1/2025, those materials will then be added to the forms section that you go to where you look for all of the forms B101, et cetera, and all that they will be then transferred over from pending to that because they will be effective on 12/1. So let's look at Rule 8006, and this is really just a clarification that any party can file a request that the Court of Appeals will have a direct appeal from a bankruptcy court. And you know, more often than not, we have an appeal to the Bankruptcy Appellate Panel, or we'll have an election to go to our district court. In all these many years here, I think we have one hand worth of direct appeal requests. We don't have very many of them, but they do happen because there are certain matters that just need to have policy level driven decision making, and that's really where the Court of Appeals falls into place. So this just clarifies, again, any party to the appeal can make this request.
We have created a pathway, the different event pathways for the September 1st rules. The names of the events are a bit cumbersome, but we did that so that they matched exactly what the forms are called. So we have the motion under Rule 3002.1 F1 to determine the status of a mortgage claim. And due to the fact that that is a motion, you're going to find that under motions and applications, just like all of our other motions. We also included it for the Chapter 13 trustee. It'll be under the trustee U.S. trustee events. When it comes to the response to the motion to determine the status of the mortgage claim, we place that in 3 different places. One is for claims actions, because this is, of course, related to claims. We put it under other miscellaneous events, where we put many of our different events. And then we also put it under creditor filings, and that would be for limited user filers, creditors, so that they can also file that response. The third one that we have is the one that is replacing. It's going to replace our current event, Notice of Final Cure Payment. On December 1st, you will no longer see Notice of Final Cure Payment as a choice. And instead, it's going to be called the Trustee's Notice of Disbursements Made. As I understand it, this is going to be an event that is only going to be filed by the Chapter 13 trustee. So we placed it under the trustee, U.S. trustees events in CMECF. For the response to that trustee's notice of disbursements made, it is replacing the event response to notice of final cure payment. And again, like the other response, we placed it under claims actions, other miscellaneous events, and for our limited user creditor filings. Number 5 is that motion under 3002.1 G4 to determine final cure and payment of the mortgage claim. It replaces our event that we currently have in CMECF, determination of final cure payment. So again, determination of final cure payment will cease to exist in CMECF on December 1st, but this motion will be there instead. And because it's a motion, it'll be under motions and applications. Number 6 is our response to motion to determine the final cure and payment of the mortgage claim. And just like the other responses, you will find that under claims actions, other miscellaneous events, and also the creditor filings. These events, we have a few things that are a little bit different than how we have had motions in the past work in CMECF, and the same thing for responses. So we thought it would be best to take a moment to sort of give you some screenshots of what this event will look like in CMECF. These screenshots, as you see them, these screenshots will appear for both the motion under Rule 3002 F1 to determine the status of the mortgage claim, and also for Rule 3002 1G4 to determine the final cure and payment of the mortgage claim. So the first thing that they will be found for the filer is that the filer can set the motion for hearing. This is not different than other motions that we have. You, on most of our motions, you have that opportunity to set it for hearing if that is appropriate for that motion. Number 2 then is the filer is going to be required to attach the appropriate PDF form for the motion. So as was discussed earlier, you are required to use the forms that come from the federal forms. And so at that point, you'll be able to attach them as a PDF, just like you do for any other document that you're filing with the court. Number 3, the event is going to ask that the mortgage holder be added as a party within the case. This will help with our docket text. It also gets the mortgage holder to be already a part of the case. So whoever has that mortgage, you're going to add them. And these are the screenshots. So first you're going to see a screen that says on the next screen, you need to add the mortgage holder. You will then add that mortgage holder. You'll have to select that party. And then if we go down just a little bit more, if the mortgage holder, if they're not a party that is in the CMECF system, then you would need to add that information to add them as a party. Number 4 is common for when there are claims involved, but the filer should select the appropriate claim related to the motion being filed. This helps so that all of these documents will then appear on the claims register. So you're going to select that appropriate claim, just like you would on other things when you're working with claims. So that's not uncommon, but you will be required to do that. And then the last thing is that we are going to ask that you enter the date of the motion and that the motion and notice were served. Often this is going to be the date that you are filing this document, but you will be required to enter that date. The event will not allow you to continue on until a date is entered. And the reason that we need this date is because the deadlines related to these events will be figured from the date of service. And so that's why that's required. It'll also appear in the docket text. When it comes to the responses, 2 of the responses, you would not have to do the service date, but on the 3rd one, we will require the service date. So if the event asks for the service date, you're going to need to add it. If not, then that's one that it was not required, so it's not part of the event. But when it comes to these responses, I thought I would show you real fast how this will work. You have you will attach the appropriate PDF form from those federal forms, just like you always do. Number two, the responded event can only be docketed if the appropriate motion or notice has been filed in the case. So if a notice, in this case, the trustee's notice of disbursements made, if that has not been filed, you will not be allowed to file a response. So the event will stop you. If it has been filed, you're going to see that notice on the as a choice. It'll already be checkmarked for you, and you can just continue on and hit continue. The filer should select the appropriate claim again so that this will appear on the claims register. And then number 4, when it is a response to trustee's notice of disbursements made, the filer will be asked to enter that date that the response was served. Again, because there are deadlines that are being set off of that, and then also that date will be in the docket text. So hopefully that will be helpful as these new events take effect on December 1st.
Just a few quick comments on the new Rule 3002.1 and how I'm going to be addressing it. I want to reiterate what everybody said before, is that the new forms under the new Rule 3002.1 are mandatory forms. That said, there's going to be a little period of awkwardness right after December 1st, because prior to December 1st, anything that I would file or anything that will be filed under 3002.1 would be under the old rule. So, for example, if I filed a notice of final cure under the current rule before December 1st and the deadline to respond falls after December 1st, I don't think you can use the new form to respond to that motion, because it's a different motion. It has a different name. So just be aware there may be a little bit of awkwardness in that initial period. And actually, from what Jennifer said, I think you probably can't use the new forms to refer to that, if I understand correctly. On the motion to determine the status of mortgage, that new mid-case motion, I do not plan on filing that in every case. I will file it only if I have a reason to believe that the creditor's records on the mortgage that I am paying don't match my records. The big example of that would be if the creditor is returning disbursements to me, or somehow contacting the debtor and saying that the loan is in arrears when I think it's current. Debtors can also file this motion, not just me, but I would suggest not doing so unless it serves a purpose. It involves a lot of work for the creditors to respond to these motions to determine status. And I would be very surprised if they did not attempt to charge those costs against the debtor's account. So filing those motions gratuitously when there's no reason to believe they're a problem may not be in the debtor's best interest. On the end of case notice, which will now be the trustee's notice of disbursement made, I plan on filing that in all completed cases with a mortgage unless the stay has been lifted. That is regardless of whether I made any payments on that mortgage claim. And I will be filing that even if we think it's not the debtor's residence, simply because it is what was the debtor's residence at the beginning of filing may change during the life of the case. And I think regardless of whether the property is the debtor's residence or not, there is a benefit at the end of the case in making sure that everybody is on the same page with the status of that mortgage. I won't file the motion in cases that have dismissed or converted, and I do plan on attaching a copy of the payment ledger to the motion rather than referring parties to a website to see the payment ledger, which is an option under the rule. I think providing that printed ledger is the best option. On the motions to determine final cure, I I will only file one of those if a creditor states that the payments that I made are not current. So again, the creditor's records disagree with mine. That is the same as the current policy, no change. Debtor can also file those motions as they can currently. Just to note that under the committee notes, if the debtor files the motion, they should certainly provide information about payments that the debtor has made. They should also provide information about payments which I have made if the trustee has knowledge. Well, you have knowledge because that motion to determine final cure had information on payments in the attachment. I would ask you though to check my website and records just to make sure that nothing has changed since that motion was filed. I think it would be unusual that it would, but just to make sure, you might want to do that. All right, that is all I have. Thank you.
So this brief presentation will just be about the department's policy update, the standard that we've been using for motions to dismiss for failure to submit state tax returns. So briefly, I want to introduce three members of our team involved with this. I'm the managing attorney of the bankruptcy unit at MDOR. Got Kelly Pointer, who's in charge of our 12 staff members devoted to filing claims and processing Chapter 13 payments. And Ivy Rochelle Painter, who is the legal assistant, helps me with dismissals and who also processes the tax returns and the affidavits and declarations you send in lieu of tax returns. So this is section 1308A of the Bankruptcy Code. It provides that no later than the day before the date on which the first meeting of creditors is first scheduled to be held, the debtor has to file with all appropriate tax authorities returns for periods during the 4-year period ending on the date of the filing of the petition. So it's highlighted there for the meeting is first scheduled to be held because even if the meeting is not held on that date for some reason, the deadline for submitting the returns will not change. As you know, it's usually the 341 meeting notice is the 6th entry on the docket or so. It's usually entered the day after the petition is filed, and the meeting is held, 4 or 5 weeks after the petition is filed. So that's how much time you have from the date the petition is filed to the meeting to get those returns ready. So next slide. Section 1308 was added to the Bankruptcy Code by BAPSIPA. It took effect October 17th, 2005. This is an application if the debtor filed their Chapter 13 petition on June 1st and they were past due on their 22 and 23 returns. If the Chapter 13 trustee scheduled the meeting for June 28th, the debtor has to provide the returns no later than June 27th, the day before the scheduled 341 meeting. If the Chapter 13 reschedules the meeting to July 15th, the past due returns are still due no later than June 27th. So it's kind of set in stone. Now, what happens if you don't provide them by the deadline? We'll talk about that the next slide. Historically, MDOR has moved to dismiss the debtor's case under section 1307C1, which is for cause including unreasonable delay by the debtor that is prejudicial to the creditors. And I don't know the history of why MDOR used that particular standard and why we kept using it after BAPSIPA was enacted and 1308A was enacted. But we believe that 1308A was meant to supplant and any other standard that tax authorities were using. And we want to switch everything over to 13 and make that be the standard that we comply with. Over a year ago, IRS and Justice Department announced that they were going to start moving to dismiss cases under Section 1308A. And for almost a year, they've been doing that. So we feel like that it'll be good to have the tax authorities on the same page and the debtors bar on the same page, that we're all using the same standard. That's the standard in the bankruptcy code. So for petitions filed after January 1st, 2026, we will no longer move to dismiss under the unreasonable delay standard that we've historically used, but instead we'll move to dismiss under Section 1307E, where the debtor fails to comply with Section 1308A. So under 1307E, it's very important to realize that if that motion is made and the debtor truly has missed the deadline, the court does not have discretion to deny the motion. We had a ruling in this court in the Eastern District, the Dunlap case, where Judge Surratt states made that ruling, and that was in accord with all the other published opinions that have addressed the issue. So if you miss the deadline and we have to make a motion to dismiss, in all likelihood, your case is going to get dismissed. And that raises the question, well, what if the debtor gives us the tax returns after we make the motion, but prior to the hearing date on the motion? And the answer is the case will still get dismissed, because filing the tax returns after the deadline does not cure the violation and doesn't really have any impact on the court's mandatory duty to dismiss the case. So because we don't really want to see your cases get dismissed, we just want to get our returns, I'm going to give you 5 steps, things you can do to stop your case from being dismissed under Section 1307E. Now, you have some time. You know that the deadline is coming up right before the 341 meeting, which is about 5 weeks after the petition date. You know that's going to happen. So we would suggest, when you're meeting with your client and you're gathering the documentations that you need for your schedules, you can start at that point to find out what returns you're missing and to get those missing returns filed for the taxable periods ending within the last 4 years. Unfortunately, our bankruptcy unit we don't have the resources to help people who plan to file bankruptcy but have not yet filed. But you can certainly call the Department of Revenue on the phone number that's provided here, the fax number. You can email them, and they'll be happy to tell you what returns your client is missing. If your client gives you a power of attorney and provides that to us, then whoever's listed on that power of attorney, whether it's you as the attorney or a staff member, our representatives will provide the information to that person just like they would the taxpayer. Another option is we do have a tax portal. Your client could register or authorize you to register with that tax portal, and they'll send you a PIN number, which will come in the mail in a week or two, and then you can see what returns are missing through that portal. So the first step is, be proactive. You don't have to wait to the petition date to find out what returns are missing and to make sure that they're getting filed. Second step you can do, after you file the petition, you can reach out to me or you can reach out to Ivy. You could say, my client's filed for bankruptcy. Here's the case number. What returns do you need per Section 1308? And we'll get back to you in a day or two and let you know what returns you need. By that time, you'll have 4 weeks to get them. That may be enough time. If you don't reach out to us and you don't get your returns filed through other channels, as a courtesy, not as an obligation, because we are not responsible for your client's duty to file these returns, but as a courtesy, we will endeavor to send the debtor's counsel an email letting you know what returns your client needs to satisfy Section 1308A. We'll do that usually within 5 days of the petition date, because we don't get notified right on the petition date. We get notified of the petition a few days later. We'll do our best to let you know what returns you need to submit to satisfy 1308A, when those returns are due, and the consequences of failing to provide the returns, which is dismissal. And after you or your staff send us the returns or the affidavits and declarations in lieu of the returns, we'll send you a confirmation email stating that we've accepted those returns and that we will not file a motion to dismiss. And you know you're off the hook. You don't need to worry about us doing it. If we've notified you and you still haven't got the returns to us by the deadline, the day before the 341 meeting, you can stop dismissal by asking the Chapter 13 trustee to keep that meeting open for a reasonable period of time. That is totally up to the Chapter 13 trustee. She has total discretion over whether to give you more time and hold the meeting open or whether not to, and for how long. It's totally up to her, except that she can't give you more than 4 months for returns that are past due or 120 days, or for returns that aren't due yet. She can't give you past the time when the returns are due, including extension. But I've seen the Chapter 13 trustee continue these meetings before. It is, there is precedent for doing it. That's another way to keep, we will not move to dismiss as long as that 341 meeting is held open. We won't move to dismiss even if you haven't submitted your returns by the deadline. This is an example. The debtor couldn't file their past due returns by June 27th, the deadline. They asked the 13 trustee to hold the meeting open. Because the returns were past due, the 13 trustee can't hold the meeting open more than 120 days. Again, we won't move to dismiss. We'll check the docket. If we see that that meeting has been continued or is being held open, move to dismiss. So if you're in doubt about whether we have the returns that we need, go ahead and ask the trustee to hold it open, please. The next step, the last bite at the apple, is if the Chapter 13 trustee informs you, or if you believe that she will not keep that meeting open any longer and you still need more time, you can make a motion to the court. It has to be noticed and heard and the order entered prior to the expiration of the extension that the Chapter 13 trustee has already granted. And you're going to have to show by preponderance of evidence that the failure to file the return within the time allotted by the Chapter 13 trustee is due to circumstances beyond the control of the debtor. So that's an accelerated time frame, and it's a tough burden. And that is the last bite of the apple. The court can extend that period for another 30 days for past due returns, extend it up to the due date for returns that aren't yet due. This is the last slide. Just say that the longer you wait to file the returns required under Section 1308A, the more dependent you become on the mercy of other case participants, and the more likely your case is to get dismissed. So we urge you to file your returns early. We'll do what we can to help you. We don't want to dismiss your case. But please file early if you can and stay in control of the case. That's all I got.
On behalf of the judges, we want you to be aware that we're changing 341 scheduling in 2026 in order to reflect the new case assignments. Chapter 13 confirmation dockets will continue next year to be held on Thursdays. As she has in the past, Judge Surratt states we'll be holding 2 hearings a month. I will be holding 1 hearing a month, and Judge Walsh will be holding 1 hearing a month. Please take a look to make sure that you're reaching out to the correct courtroom deputy to ensure that you're scheduling hearings on the correct date with the correct judge. And as always, please take a look at your captions to make sure you're listing the correct courtroom for hearings to occur. And I'll ask Judge Walsh, have you decided what you're going to do on motions to extend stay? Are you going to extend the deadline, or are you going to hear them within the 30 days?
I think it depends on the timing of the motion relative to the timing of my next available hearing date. But in hearing cases in Cape Girardeau, where I'm only there once a month, my general practice has been, if the motion to extend the stay on its face appears to include the content that might justify an extension, if found to be true and credible, I will typically enter a bridge order extending the stay until a further hearing date and providing some additional opportunity to supplement the motion and to object to the motion. So I think in many cases that would be the practice I would follow in certain cases.
So in order for that to work, it is imperative that motions to extend the stay are filed timely, not on day 28 or day 29, and within the 14 days for that provided under the local rule, so that arrangements can be made for a hearing, a bridge order, or a conference with the court, depending upon the particular circumstances.
Makes sense?
Makes sense. All right. I would add, in light of Mr. Tree's presentation, it certainly seems that if the Department of Revenue files motions to dismiss for failure to file, they will not be as generous in agreeing to continuances, because they are certainly going out of their way to make sure that people know well in advance whether or not the tax returns are due.
And one thing I think you can conclude is, if the Department of Revenue does not have tax returns, it is probable, although not always so, that federal tax returns have not been filed. So please plan accordingly and speak with your clients. Please take action to avoid issues in this area. We've been working under the IRS's policy, or increased enforcement on the motions to dismiss over the last 10 plus months now. I have yet to have a motion come before me asking for additional time to file tax returns. Have you had any, Judge Surratt States?
No, I have not.
So this is something within the control of debtors' counsel. Please please prepare to take action if you need to protect your client's rights. As Mr. Treese did say, this is within your control and your client's control. Could I pose one question to Mr. Treese?
Please do, please.
Mr. Treese, am I correct in believing that your office is going to go ahead and start letting attorneys know about unfiled tax returns prior to the first of the year?
Yes, we've already been emailing attorneys over the past couple of weeks, letting them know what returns they need to satisfy 1308A. We're going to continue to do that through the end of the year, and we will also include in those emails just a notification that we're going to change our standard for petitions filed after the first of the year.
All right, and Mr. Treese, I don't know, was your PowerPoint provided to practitioners or prior to today's session, or would you be all right if we permitted that to be circulated to counsel for those who have not had the opportunity to attend the seminar?
Yes, Judge, this is Matt Rodman. I have a copy of Mr. Treese's PowerPoint, and now is a okay time to say it. I will post that PowerPoint under the attorney information section of our website. I will also include some of the CMECF changes that Jennifer Dawson spoke to us about as well. So all of that information will be under attorney information in the coming days.
So with that, I think we have done quite well. Judge Claire, anything you would like to end this with?
One thing to add, if you find the local rules fascinating, or if they don't reflect the practice that you'd like us to have, please, we'll be soliciting next year for additional members of the Local Rules Committee. We invite all of our practitioners to apply to serve on the committee and to participate. as the committee each year looks through the local rules, discusses potential changes and modifications, and works with the judges as part of the local rules process. The bar is an important part of the community here, and without their participation in the local rules process, the local rules do not work. We appreciate the efforts our local rules committee makes and thank them for their service to the court and the bar. If you are interested, please watch your email. Matthew Rodman coordinates the committee and convenes their meetings. Typically, there's a few meetings each year to deal with these issues. And if you choose not to be on the committee, we will be publishing the names of the committee members. You can always reach out to the committee to ask questions or make proposals about things you'd like to see in the local rules.
With that, we have completed our seminar for today. We encourage you to let us know whatever questions or comments you have. Please spread the word so that others have the benefit of this seminar, and we are hopeful that you benefited today. Thank you so much for your attendance. With that, we are ended.